Good afternoon.
Buenos tardes, señor.
Yo español, muy bien.
You know, I'll try.
Okay, so welcome to the consultation. We're going to do the show in English today, right, James?
See, I mean, yes.
Perfect. My name is Josh Floyd. I'm one of the attorneys here at Jimenez Law Firm.
My name is James Pale, and I'm also one of the attorneys here at the Jimenez Law Firm.
And we come together every Friday at noon, or most Fridays, unless we're all on vacation, but most Fridays at noon, and kind of talk through some family law issues. People post questions on Facebook or send us in questions, and we kind of take this opportunity to chat about them. Whatever you do, don't take this as legal advice. You'll hear as we're going through it that our opinions and outcomes and all of that changes on any little fact or jurisdiction that you're in, or even the attorney that you have, right, could really determine the outcome. So don't take anything we say here as legal advice. If you have issues in the area of family law, we advise you reach out to an attorney that handles family law cases, that's experienced, and that practices in the jurisdiction where your case will be heard. And then, follow us on, of course, on Facebook, but also on Instagram and TikTok and LinkedIn and Twitter. And is that it? I think so. Pretty much any social media platform, we are present. That's it. Anything else?
Yeah, let's get to it. I'm excited.
All right, let's roll. You want to read the first question? You want me to go?
I got you covered. I want to file a motion to terminate child support, but who do I serve? The mother? My child turned 18, but payments never stopped. I've been paying child support although my child is 18. The child support office won't answer or respond to my calls. My child is not in college. He has his own business with my help. I thought it stopped automatically, but it continued. How do I terminate the order, and who do I serve?
Yeah, so this happens a lot, right? I mean, it happens in cases like this, but also with step down provisions. And so basically what that is if you have more than one child. So for example, if you have 3 kids, when one graduates, your child support gets reduced. And when the second one graduates, it then gets reduced again. So it happens a lot. The reason it happens is because with the order, when the order is signed, there's also generally what we call an income withholding order that's signed. And that's an order from the court directing your employer to withhold a certain amount of money from your paycheck each month and to send it to the Attorney General's office for child support. That order doesn't generally speak to a reduction or termination or anything like that. And so your employer is under a court order to withhold those payments. A lot of times you can get the Attorney General to send some stuff into your employer and terminate the withholding. But I mean, I've had several cases where I've had to go in and file to have the income withholding order terminated. That way it would stop the support. Though I do want to point out, because here this person is talking about child support he doesn't owe anymore because the child's 18. So 18 is important, but the second important part is the child has graduated high school, right?
Right.
And if they haven't graduated, that they're still enrolled in school, right? So that's when your child support would terminate. How do you terminate the order? If you can't get it done to the Attorney General, then hire an attorney and they'll file a motion to terminate and hopefully get it stopped that way. See? Did I lose you, James?
No, I'm still here.
Okay. Anything else on that? It's pretty straightforward.
Yeah. Yeah, the Attorney General. And they're usually pretty good. That's tough. That's tough.
But it's hard for the state to keep up with all of this, right? And so generally you can call them or get in touch with them and tell them, hey, it's 18, he's graduated high school. Sometimes they'll want proof that he's graduated, and then they'll do the termination thing. But you want to do it sooner rather than later, right? Because I know that you're paying all this extra money. And I assume what you're going to be asking is that if that money has been sent to mom, that you get that money back, right? Because she wasn't entitled to it. And the longer it goes, the more difficult it's going to be. So,
yeah. And every time I've ever called the Attorney General, I've always spoken to somebody. It might take a little while on hold, but you reach out to that hotline, they got lots of agents there to help. Okay.
yeah, sometimes it can be a pain to, I mean, anytime you come call a state agency, right, you sit on hold forever and ever and ever. But yeah, all right. So you want to move to the next question?
Yeah, sure.
Kind of similar, right? Can I get child support eliminated from the order if I can prove my child only goes to daycare 3 months out of the year? The current order states $250 a month for child care monthly. I can prove my child only goes to child care for 3 months. If I brought to court, will child care be removed or reduced?
Yeah, so removed, no. I don't know that this qualifies as a material or substantial change either. So your child support is going to be based off your income. Now, if there's an added consideration within the child care, perhaps you can prove that, you know, the opposing party was lying when they sought additional monies, but that's not going to terminate your order. Mr. Floyd touched on it in the previous question. Is going to require that 18-year age and then graduate from high school or whichever comes later. Now, yeah, it's no good that, you know, perhaps someone misrepresented some information to the court to make you pay more. That being said, I don't know that that would be considered a material substantial change for you to modify. Floyd, you're on mute.
So what if it wasn't a misrepresentation? What if the order was entered when the child was 3 and the child was going to daycare every day, and now the child's 7 and goes to school and only goes to daycare during the summer months?
Well, that 4 years you can modify anyway. So to that example, I mean, you may seek a modification in that sense, but even still, you're not going to get child support terminated. That's just not going to happen.
Yeah, so I guess what I'm confused about is, I don't know if, I mean, it doesn't look like maybe childcare was ordered in addition to child support. So he says the order states that he pays $250 a month for childcare, right? So is that in lieu of child support? Right, so there's not a child support order?
Yeah, I thought that was interesting, but yeah, I don't know.
So if that's the case, right, then you may just want to keep paying the $250 a month, right? Because if you eliminate that and they go in and calculate child support, assuming that you just have this one child, right, it's going to be 20% of your income. And $250 is right at the minimum wage amount. So that's the minimum that you can pay if you go in there and they order you to pay child support instead. So if this is in lieu of child support and you want to go remove this, you can, but then they're going to tack child support on you, which would be more.
So yeah, this is an interesting predicament this guy's in. And I wonder how you can prove that the child only goes for 3 months.
Pull the daycare records.
Right, but there can be multiple daycares, right? Yeah, you go to La Petite, you know, from January to March, but then I go and put them in, you know, the Palin House of Humanity for the, you know, from January, or not January, from March to April, you know.
I can assure you my child would never attend that daycare.
Hey, well, first off, we have a very strict qualification process. So
my kids wouldn't qualify.
Yeah, I'm not saying that. I'm just saying, you know, we don't just rubber stamp the babies in there.
Got it.
Yeah, very, very tricky, but okay. What do you think? Next question.
Yeah, I think so.
All right. How do I continue to pay for my 18-year-old's recent medical bills since my ex no longer pays me child support? I see a theme going on here.
Yeah, this
Appreciate
is
it,
child
Keon.
support.
I mean, people want to know. All right. My ex-husband and I had the agreement to pay 50-50 on our children's medical expenses after the divorce. The only income I get is what he pays me in child support, which is $250 per child per month. The ex immediately stopped her child support payments, but still expects me to pay her medical bills. Now with 2 kids under 18, I only get $500 a month in child support, and that is all the income I get. I was paying some of the medical expenses out of her $250 payments, but since he stopped her child support, how do I continue to pay, or do I even have to? What do you think?
Okay, so this question can take us down a bunch of roads. It's a good question.
Yeah.
So do you have to? Let's start there. No, you don't have to. You always have choices in life, right? And there's gonna be consequences. And the answer to this question really depends on what exactly is in the divorce decree, right? So maybe it doesn't actually. I was thinking that if they were ordered to pay, if each party was ordered to pay 50% of this medical bill that existed, Did I read into this question?
Yeah, I think you did. It all it says is we had an agreement to pay 50-50 on our children's medical expenses after the divorce. And
Okay.
so where I thought you were going to go is he's no longer a child in that he's turned 18. Similar, just staying with what we've said, the first question, second question.
Okay, so I'll just go down the road of what I was saying. What I was thinking was that there was an outstanding medical bill at the time of the divorce, and they were making payments towards that, right?
Okay.
And now the child has graduated, the parent's still responsible for it because they were responsible for the child at the time the service was rendered, right? So that's what I was thinking. And if that were the case, then it would depend on how so if the order specified that you guys each have to pay half the medical bill, this specific medical bill, until it's paid in full, this is a lot like any other debt in decrees, right? I mean, it has no teeth. You can't enforce it. There is no debtor's jail, right? The consequences of not paying for it is it hits your credit or whatever. And so if it's a medical bill that you're still responsible for because you were the parent, you both would be equally responsible for it. It would hit both your credit, et cetera, et cetera. If that were the case. If it's like James is saying, where there was no outstanding medical bill at the time of the divorce, but you're talking about just the standard language where you guys split equally the unreimbursed medical expenses, which those are expenses that insurance doesn't cover, right? So if that's what you're talking about, then after the child turns 18 and graduates from high school, neither one of you have an obligation to continue to provide support. We all know that most of us still do, right? But it's no longer an obligation. And so you personally are not required to pay 50% of her medical bills anymore. If you do so, it's a gift, it's a kindness, it's nice, but you're not required to do so, nor is he required to do so either. So I understand that if this is a situation that you're helping your daughter out by continuing to pay some of those medical expenses, but you don't have to. There is a remedy though. So $500 in support for 2 kids, not a lot of money.
Right.
Maybe we look at seeking a modification of that support, and we can get the child support increased for the 2 kids that are still under the age of 18. And that increase of support would then amount to what she was previously receiving or more right? And allow her to continue to use some of those funds to help her daughter out.
Okay, and so these sound like, and I'm reading into the question a little bit. So here's your.
That's okay. I did earlier.
So these are continuing medical bills, and it sounds like they're going to be ongoing. Now, there is a provision where special needs children, right, can qualify for support after that 18-year period, and even after that high school graduation period. So now you didn't say this, that your child is special needs, but perhaps they are, and that's why you continue to have these medical bills you're faced with. Mr. Floyd, would that be an option, or is it there in too late?
No, absolutely, right. So yeah, you could file for support for an adult child. You'd have to prove that basically they're going to be continuing to rely on your income and your support. A lot of times this doesn't work because what I've experienced anyway is when they get 18, they get some type of Social Security, disability, something like that provides for their support. And so it's not coming out of the pocket of the parents. But if that's not the case and you're still having to cover expenses and things like that to make sure that your daughter's taken care of because she can't take care of herself, then yeah, sure, you can go after child support that goes past 18.
Still nice.
So let's talk about, so they did $250 a month per child. I'm assuming that's not guideline.
Right, yeah. Somebody's a co-negotiator between the two of y'all.
Yeah. So there's special rules with regarding modifications of support when you agree to deviate from the guidelines, either increase or decrease from the guidelines set forth. I don't know what his income was at the time or it is now, so I couldn't tell you what the guidelines would be. For 3 kids, it's 30% of his net income. For 2 kids, it's 25, assuming he doesn't have any other kids. So I don't know what it would have been, but when you deviate either way, up or down, it makes it a little more difficult for you to modify because the courts look at it like, you agreed to deviate for a reason, right? We didn't just apply the guidelines. We didn't use income to calculate the support. And so if you go back and try to argue he's making more money now, and so I want to increase his support, the court's going to say, no, you didn't use the income last time, right? You don't get to use it this time, right? So that you can't just use it to your benefit. But you can modify if you can show that there's been a material and substantial change in circumstances, and maybe her graduating and your income being decreased by $250 a month. Maybe that's enough to do it. But there's certainly some hurdles to overcome. I wouldn't say that they're not so high that Mr. Palin can't hurdle them, because he can hurdle. You should see him on the track and field meets.
How did you know? Okay.
I can read. I
thought it kind of blended in with the shirt, but okay.
No. So there's some options. I would advise you to reach out to somebody that practices in your area and handles family law. Don't take this as legal advice, right? Because we're just kind of talking through some issues, right, James?
By all means, please do not. All right, Lex.
Your turn.
All right, so did I read the last one?
Yeah, you did read the last one. What, do you want to read another one? Are you trying to show off your reading skills or what?
I'm just saying, you can read, I can read. It's a skill we both share. All right, so in Texas, what is the breadth of reasonable diligence before a spouse is served divorce papers via social media? Like, we're on social media, Facebook, Instagram. What is the breadth of reasonable diligence before someone can be served via these avenues, Mr. Floyd?
I'm really unsure what that means.
I think it's something about alternate service.
Yeah, that's what it appears, but the breadth of reasonable diligence. So I guess they're asking how you could serve somebody via social media. Well, you have to file a motion with the court. Well, let's talk about service in general. I know we've talked about this, but maybe we have some new viewers that haven't had the opportunity to hear us discuss it. Generally speaking, whenever a lawsuit, in this case, a family lawsuit, a divorce petition for divorce has been filed, you have to personally serve that party with your copy of your petition. So a constable or somebody that's authorized to serve papers through the state of Texas goes and physically delivers them a copy of your petition for divorce, fills out what we call a return of service, which just states that they serve someone, they file it with the court, and then the court knows that this person has received a copy of your petition. Now, in some circumstances, we're unable to physically deliver those papers to the individual. Numerous reasons. They may be out of the country. We may not be able to find them. They may be incarcerated. They may be incapacitated, whatever, right? And so then there's a provision where it provides for service via alternate means, right? And what's required for that is you have to, most of the time, there's some exceptions, but most of the time you have to attempt personal service 3 times, or have your process server do it, or constable, whoever. Attempt service 3 times. Then you have to file a motion with the court and attach an affidavit from the process server stating this is what we did to attempt service. We were unable to serve them. And this is how we believe we could serve them, or how we believe they would get actual notice of the petition. And it can be any means, right? I mean, it can be text message, it can be social media, it can be leaving a copy on the door, it can be giving a copy to somebody else that's in the house. Email, I don't know if I already said email. It could be, leaving with a certain individual or at work or whatever. Any way that you can convince the judge that this person would get actual notice of your filing, they can authorize service to be conducted in that manner. So in your situation, we have served people via social media before. Facebook Messenger specifically is one of the ways we've done it. And so you just prove to the court, that you're communicating with this party via Facebook Messenger, that this is them responding. Usually we do that by context of the conversations. They're talking about kids, or talking about the divorce or whatever, something that only you guys would be talking about. And if those messages are recent enough, then it's reasonable for the judge to assume that if you were to send photos of the petition via Facebook Messenger, then they would get notice. And so the judge would then sign an order authorizing you to serve them via social media in this case, and that would count as actual service. So I guess that's the breadth of reasonable diligence.
Yeah, I like it. I like it. And just in summary, try real hard to get them where you know they're at, and then let the court know.
Precisely. And don't be shady. Don't say you don't know where they are if you do, because it's going to come out, and then everything you do is going to be overturned, and it's going to be really ugly, and judges are going to be really mad at you because you misled the court and were less than honest with them. You're going to be paying attorney's fees. It's going to be ugly. So, do your due diligence, do the best you can. And if you can't serve them, let the court know, and the court will help you.
Nice.
All right, my turn to read.
Let's do it.
Am I legally required to turn over child support arrears to my adult son who wants to leave home before he graduates college? My 20-year-old son is attending college online and working. We agreed that he would live at home rather than live on campus to save money. I have few expectations of him, but since he turned 18, he feels that he no longer needs to do things that I ask of him. He is demanding that I hand over the debit card that child support arrears are applied to by the state. This card is used each week for groceries, which he partakes in, of course. I need support as well. I know it sounds selfish.
You know, Ahmad, that doesn't sound selfish.
It does. It sounds selfish on behalf of his son.
Oh, of the son, yeah, yeah. But I thought this parent was saying, hey, this helps me. I need this support, and child support is allegedly his. But honestly, I don't know that direct answer. I mean, I think no, because she's the one with the order, and it's being directed to pay to her. Now, we've seen cases in the past where the kid wants to come back and say, hey, look, so-and-so didn't pay child support and they're behind, and I'd like to put in orders and get what we have on arrears. But in this case, I'd have to defer to Mr. Floyd, but you don't sound selfish. Yeah, that's.
Yeah. So first I'll say kick his ass out of the house and let him know what it's like to live in the real world.
Is legal advice.
That is legal. You could take that as legal advice. Yeah, so if you're gracious enough to allow him the benefit of living in your home rent-free, I'm presuming, and he thinks he doesn't have to follow your rules, sounds like he needs to know what it's like to go pay some bills. But when you do that, no, you don't have to turn over the support card. In this case, I'm assuming what happened is there was a child support order, the person paying support got behind, right? Because child support is no longer owed. He's 18, he's in college. So there's not a continued obligation for support. But I guess the person got behind and is still making payments towards the arrears that the person didn't pay when the child was under 18, right? And so the rationale behind that is that's money that you should have received years ago, right? When you were providing support for the child, right? And so it's repayment for that money from when the child was under 18, the money that you spent supporting the child. So no, that's your money. He's not entitled to any of it. He's not even entitled to the damn groceries that you buy with it. You are nice enough to let him eat it. But maybe you should rethink how nice you're being, give him a rude awakening, teach him a little humility, and then he'll come back and be appreciative of the things that you're doing for him.
Well said. I don't disagree, except for the kicking out on the street part. That perhaps we differ there. Because, you know. Yeah,
you just let your son live in the house, tell you he can do what the hell he wants, and he doesn't care what you say.
We have a certain discussion, same discussion my father had to have with me. It turned out all right. And I got a new tooth. I'm just kidding. Yeah, those are some interesting circumstances that I hope you all resolve.
All right, so I'm gonna read the next one too. You got to read two, I get to read two.
Fair enough.
What steps need to be taken when a mother wants to move my child 800 miles away and I don't agree with her? I wouldn't mind if she would move, but she's moving to be with her boyfriend and she has problems with relationships. My son is dyslexic, so he's getting help, and I'm afraid he'll get lost in the system, and I'd hate for him to be moved around if it doesn't work.
Sapson.
Valid.
Yeah, 800 miles, that's pretty far. Yeah, I'd hire a local attorney that knows what they're doing and follow Sapson. Unless there's some horrible facts that you're not including here. I mean, judges that are gonna rule to allow mom to move the kid so far away from you, very few and far between. I mean, honestly, I don't know any. So even if you don't go for primary, I mean, there's gonna have to be a really good reason apart from her going to live with her boyfriend. And even with that good reason, I don't see many judges allowing her to move that far away, especially when you are outright objecting. The fact that your kid is also dyslexic, I think helps you. and that, hey, look, you want to be as close as you can with him to help support him in all that he has to go through with his additional tutoring and schooling. So that's what I'd say. Do find an experienced attorney in your area, hire him, let them know you want to file, and stop mom in her tracks.
Okay. So I think, well, I guess we're presuming there's not an order, right?
Yeah, I did presume there was no order, because
What if
maybe
there
there is
is?
one and she can. What'd you say?
What if there is an order?
If there is an order and she's allowed to move the kid wherever she wants, then what, TRO?
I don't know that. So a TRO would require some type of significant impairment, right?
Right. And that, hey, and then, I mean, we're stretching here, so put your yoga pants on. She's poor with relationships, and then these frequent relationships she's chasing are going to be detrimental to my child's health and development, particularly as he goes into a educational difficulty in maneuvering his dyslexia.
You might be able to sell that, right? If it's like a new relationship, maybe if the boyfriend's got some criminal history, if this is the only school the child's gone to and he's been excelling because of this dyslexia therapy he's getting, you might be able to sell significant impairment in that situation, maybe. But if not, then you file a modification and you get it set for a final as quickly as you can.
Okay, but in the mod, all right, and I'm just playing the opposite. In the mod, judge says, well, what's the big deal? We had the order, especially say it wasn't agreed. I don't know, Rule 11, say it was an MSA, right? And he agreed to allow mom to go wherever the heck she wanted. Right. So I feel like we've been in a similar situation to where a judge says, hey, you thought it was good back then. What's the deal now that she's actually, taking the order by the words of the order and getting out of Dodge?
So obviously it depends on this person's specific facts, but I feel like my client would say, that was several years ago. Me and my son have gotten a really close relationship. We see each other every 2 or 3 days. I'm coaching his football team. I'm helping with his homework. And him being ripped away from me like that would really cause him serious emotional harm.
Hey, if you're selling, I'm buying. So, okay.
Yeah. So if it's a mod, then you have to try, right? The worst the judge can do is tell you no. But if it's an initial suit, original SAPSR, so there's a couple things to be careful of, right? So first, when you file an initial SAPSR, you can get a TRO issued. Under that scenario, it doesn't require significant impairment because it's an initial SAPSR, not a prior order. So you can get a TRO issued stating she can't move, right? The TROs generally say you can't move the child outside of the jurisdiction or outside the state of Texas, depending on which county you're in. So that would stop her from moving until you could get to a hearing, right? If you let her move first, you may run into some problems. If she remains within the state of Texas, she's moving 800 miles away. And so if she moves 800 miles and is still within the state of Texas, which I believe you can do, because I think it's 773 miles from East Coast to West Coast on the state of Texas. But if you were moving furthest north to furthest south, I think that's about 1,000 miles. So it is possible to move 800 miles and still be within the state of Texas.
Our listeners did not know this, but Mr. Floyd used to do cartography and was an avid Boy Scout, which is how he knows these random geographical facts about the great Texas.
That's true. It's true.
73.
You didn't know that? 773 miles from east to west?
Nope. Mr. Floyd, I didn't know that one.
Well, so we also provide geography lessons on the consultation as well. So the state of Texas is 773 miles from furthest east to furthest west, and furthest north to furthest south is about 1,000 miles. So
I should Google that. Hold on a second.
you should Google it.
It's not that I don't believe Mr. Floyd.
I know. Trust but verify. So point is if she stayed within the state of Texas, jurisdiction follows the child in that case, right? And so right now, the court that would have jurisdiction over the SAPSR would be the county that your child lives in. Once she moves, the county she moves to then has jurisdiction. So you would be fighting that battle 800 miles away, right? What's that face for, Mr. Palin?
773 miles.
Yeah, that's what I thought. That's what I thought. I couldn't remember whether it was 74 or 73, but yeah.
Okay.
But if she moves out of state, which if you had put 1,001 miles, we would know she was going out of state at that point, right? That's dead giveaway. So if she's moving out of state, then the county the child's living in now still has jurisdiction for a period of 6 months. So not as important then, but if she's staying within the state of Texas, you need to get it filed now so you're not fighting that thing 800 miles away. Yeah, so.
Okay.
And I agree with you. Well, let's talk about the geographic restriction for a minute. Why is that in place? What does it mean? Why do we have it?
Well, because the state of Texas realizes that it's important for a child to have both of their parents. And it's very difficult to do that when one parent is far away geographically. And it's difficult to sustain a relationship when someone is so physically far. And that's why you see long distance relationships fail. And this isn't in a romantic sense, but sometimes it means more to just be there present. And you can get a lesson, you can get a sense of how much someone cares about you via phone, telephonically. I mean, we're on Zoom now, and we care about you all, but it means something different completely when someone is actually there in your presence, in your face. And the state of Texas realizes that. And as a public policy reason, I mean, it's difficult to get those things approved.
Yeah, so I have this conversation with clients quite a bit. I don't say quite a bit, but often. Usually with dads when the baby's young and the mom wants to move, and they take the position of, look, I don't care if she moves, I still get standard possession or whatever it is. So I'm still going to get my visits. And I explained to them that, yes, you will still get your visitation or standard possession order, but what you're going to miss out on is all the extracurricular activities, all the school performances, all the parent-teacher meetings, the picking him up, taking him for ice cream for his birthday, right? You miss out on all of that stuff just because you're choosing to let her move. And so I discourage them to agree to that because I know later in life they're going to regret it when they are missing out on those things. But Mr. Palin's right, having them close, being there, that's what's important. But I am kind of skeptical as to this guy's use of his son's dyslexia, because he was fine with her moving, but she's moving with a boyfriend.
Well, I thought he said he doesn't want her to move.
I wouldn't mind if she moved, but she's moving with a boyfriend.
Oh, well, as a man, it'd be one thing if this were her fiance, but
Would it?
Yes, absolutely. Right? So she's gonna go and he's gonna go allow his son, is it, to go live with a guy who's, kicking the tires before, come on now, make a commitment like he did, presumably, right?
Mhm.
I want you to continue to, and this isn't just for you, child. I want you to continue to hold your mom in high esteem. And I don't want, back-to-back relationships with you living with these guys. What happens when boyfriend gets mad? He's going to kick him out. You see what I'm saying? A man, he has to, and not all men do, but my opinion, I believe a man has to consider the well-being in the household that his son or daughter is going to be living in.
So how does it, him being a fiance or even a husband, how does it change that?
Well, because if it's a husband, you can't just kick somebody out the house.
True, but her option would be to live there with the child under miserable conditions.
Or divorce them, get half of the house, or at least a reimbursement.
But how long does that take, right? So shit goes south and there's family violence or whatever, right? Technically, he can't kick her out, but wouldn't you want her to move out?
It's possible.
So we're left in the same boat.
Yeah, right. But even still, even if that is one of his only reasons, I don't necessarily fault him for that reason, because I think it's fair. Hey, look, this guy hasn't even made a commitment to you, and you're moving all the way out to move in with this person.
And for she may have met him on Craigslist and never actually met him in person.
Right? I mean, there's a show, was it Crawfish or something like that? Catfish, I'm sorry. Catfish, where somebody pretends to be someone online and then they go off to be someone completely different. Anyway, when your child is moving, especially that far away, you want to have a good sense of the person she's going to be living with. And sounds like he doesn't have that. And her history of negative relationships is fueling his fire. I'm not mad at him, Mr. Floyd. I'm not mad at him in the least.
So I would say, despite any of that, you don't want your son moving. I don't care if it's boyfriend, fiance, husband, wife, whatever. Keep your son close.
That's fair.
All right. I think you're up to read.
All right. So I have a restraining order from my ex-wife to make any contact with my son so I can answer his call or text if he communicates. Wait, if I have a restraining order from my ex-wife to make any contact with my son, can I answer his call or text if he communicates? She filed a divorce and placed a restraining order from my 17-year-old son, who will be 18 in 3 months.
All right. So restraining order. So this would be, I guess, an ex parte TRO, right? So an emergency restraining order is what I'm assuming. Basically, what that is if there's some extraordinary circumstances where, in this case, the father presents extreme danger to the child, then you can apply for what we call an ex parte TRO, which, do you know what ex parte means, Mr. Balin?
I'm sorry?
Do you know what ex parte means?
That means, or my understanding is solo, basically on their own.
Yeah, so one party basically. And so you do it without a hearing. You just submit an affidavit. Judge looks at the affidavit and says, yes, the child's in danger, and signs an order saying you can't have any contact with, possession of, or whatever it is that you're requesting in your temporary restraining order. And then they'll set a hearing within 2 weeks, and you go in, you have a hearing on it. But for that 2-week period, you can't have any contact or whatever it is that the court ordered. In this case, he can't have any contact with his son. And then you go to court and fight about it. So if that is the case, if that's what happened, then you cannot answer. You're not allowed to communicate with him. The order is against you, right? So you are ordered not to communicate with him. The order is not against your son. He is not ordered to prohibit. He's not prohibited from communicating with you. Yeah, that was a rough one. That was a rough one.
Yeah.
I gotta quit drinking before these things. Yeah, so he's not prohibited from communicating with you. You're prohibited from communicating with him. No, it's kind of a weird thing, but yeah, so don't answer any of his calls or texts or otherwise communicate with him, even through a third party, right? You don't want to tell your brother, hey, call my son, tell him I can't answer, right? You don't want to do anything like that. Just suck it up for a couple weeks, hire a great attorney that practices law in the jurisdiction where your wife filed this very mean, ruthless pleading, and let us go kick some butt.
Yeah, that's cold-blooded. Because even if he doesn't have any information about this TRO, he may be thinking you're ignoring him, right? And I think that might have been part of the strategy on their behalf, which is cold-blooded. But I mean, these are the games we play with the people we love, unfortunately.
Yeah, it gets dirty. Divorces get nasty. So yeah, and I'm assuming that it's a restraining order, right? Not a protective order.
Yeah, I think he would have said protective order.
A lot of people confuse those. And a lot of people think that just a standard restraining order prevent them from doing stuff like this, right? And so I guess I'll say this, like, make sure that you read through the order. If you don't understand it, get an attorney to read through it with you. But I don't know how many times I've had clients served with a restraining order, or we've served another party with a restraining order, and they think that means they can't communicate with that party anymore. That's not what a restraining order says at all. It says you can't communicate with them in a vulgar, profane manner or harass them. You can't, hide the child. You can't destroy property, things like that. Basically, the purpose of the restraining order is to keep everything the same until we can get to court, right? No shenanigans, no underhanded games, that kind of thing. So look through it, read over it carefully, and make sure that it does say that you are prohibited from having any communication or contact with your son. If it doesn't say that, then you're probably not prohibited. That gets confused a lot. Anything else on that?
No, I think we got it.
And I guess, yes, it applies even after your child turns 18, which he shouldn't turn 18 before you get to a hearing. So,
right, yeah. There's a lot of 18-year-olds, and I'm noticing a theme in a lot of these.
Well, so these days, a lot of people are turning 18. Like everybody that was born like 18 years ago are now hitting that 18 years age thing. So,
what year? What year were they born if they just turned 18? Quick.
2004.
All right, hey, that was pretty good. That's pretty good.
Of course, if it was before July.
773. All right.
My turn, your turn. Who's reading?
You're reading, sir.
How do I get away from a narcissistic ex that I'm divorced from? Sounds like you already did. So I still live under the same roof as my ex-husband and need to get away from him. He threatens me all the time to take my kids away from me, never pays child support. If he paid me child support, I would be able to afford to live on my own. I don't have money to hire a lawyer and need legal advice. This is not the place for legal advice.
So we are on to the next question. Just kidding. The man, that is tough. So it sounds like you're having difficulty getting child support and you can't hire a lawyer. And I don't know that I know any family law attorneys who work on contingency.
Not allowed to.
Yeah, so there's that. And then, yeah, so I'm assuming you're not working. Maybe your kids are super young. This is tough. We gotta get creative on this one, Mr. Floyd. They're already divorced. He's not paying, so she can't hire a lawyer. So we're not looking at enforcement.
Well, maybe, right? Maybe the AG.
Okay, how much time you got? But hey, you might as well. Better than nothing.
Yeah, better than nothing. There's also what are those, legal aid, right? So most counties have a legal aid, which provides services, legal services to people that can't afford them. So you could go apply for legal aid and see if you would qualify for an attorney. They could help you out there.
And heck, you know what? They're just words on paper. You can read, you know. I mean, it take a lot of studying, but you can get it done. I mean, if you're just at your wits' end.
Yeah, so some things I think so. Enforcements, I mean, you can, obviously, right? But because of the burden on enforcements, right? The beyond a reasonable doubt burden, the criminal law burden, because it's quasi-criminal nature. If it's not pled exactly correct, if it's not, 100% procedurally proper, it gets kicked out, right?
Yeah, and that's the risk you run. So I think you're right, Floyd. Best bet, legal aid. There's lots of attorneys who love pro bono work, want to help folks out. I'd still look into perhaps getting a job and maybe getting in with a friend, because it sounds like a very negative environment for not only you, but your children. And, as adults, sticks and stones, but kids, they take a lot of that stuff with them and develop issues, even behavioral, sometimes educational issues, due to that home environment. So it's pretty important to get them out of that, get them out of that place wherever you all are living, and do your best to finance, what they're owed, right? And get that child support that you deserve.
So, I mean, I don't know what's going on at the house, right? But if it's family violence, maybe a protective order. Get him kicked out of the house. You could do that through the DA's office. But what I was really thinking was that was kind of a side issue. So they're still living together, right? So what about his claim that he's providing actual support during this time period and she's not entitled to child support? Because right now he's paying the bills.
Right, but he would say that because he's a narcissist.
Well, of course he would, but what would a court say about that?
Well, yeah, he has a good argument.
She's not working.
Yeah, he has a good argument. Yeah, he has a dang good argument. I think we had a case very similar to this, and that was going to be our argument.
It's going to be a great argument.
But yeah, you may want to think about that one. But when I see he threatens me, to take the kids, threatens me full stop. Wants to take, right? But yeah, I don't know. What's the old saying? Don't bite the hand that feeds you.
Oh, sometimes you got to bite the hand that feeds you. Sometimes you've got to bite. So only thing I would say is call around, see if you find an attorney that'll handle it for you. Call legal aid. If it's bad enough, there's shelters, right? Attorney General, there's help out there. You just gotta search for it.
Yeah.
Cool.
Okay. What you think? Next question, we got time?
Yep. One more.
Uno más. All right.
We're doing this show in English, Mr. Phelan.
Sir, and these are the conversations Keon and I have. We're talking about diversifying our audience. I mean, it's a big world we live in, Mr. Floyd.
I do understand, but if we did have Spanish-speaking clientele listening to the show, the only thing they understood throughout the show was one more.
See.
So I don't know that properly catering to them at this time.
Okay.
And our English speaking audience didn't know what you meant when you said un mas. It's a fine line. It's difficult. Maybe we should just get an interpreter.
I know a few good ones. All
Any
right.
question?
Number 9. I'm getting ready to divorce, and the soon-to-be ex has multiple friends that are potheads and possibly uses herself. I found out the wife was cheating on me. I'm sorry to hear that. She decided to openly date a man who is a pothead and would leave the kids and myself at the house and be gone till she decided to go home and sleep a few hours and then get back up and go at it again. Stuff. She got us kicked out of the apartment for issues, and right now we are staying in an extended stay till I can get a new place. I have screenshots from her phone of texts and Facebook messages where she talks to other friends who have marijuana, asking if they have certain kind for him, if they have a certain kind for him. Some even have pics of the products. How do I keep her from having the kids around these people?
So first, I would say be careful what you post, whoever you are. And thank God we don't know who you are, and hopefully nobody else knows who you are. But there is, depending on how you got access to these Facebook messages and text messages, right? There is a criminal offense that would frown upon you getting into people's Facebook and text messages and things like that. So we're going to pretend that you had permission to get into the, and you acquired these while it was under the consent. So how do you keep the kids away? Go to court, right? Let the judge know what's going on. Most judges would have issues with her behavior. I think every judge would understand why you don't want your children around a bunch of potheads or anybody else doing drugs for that matter. So you can get an injunction put in place that would prevent the children from being able to be around anybody that is under the influence of any THC or derivative or whatever, right? And so basically an injunction is a court order that says the kid can't be around people that have been smoking weed, or sometimes it says drinking alcohol or whatever. You could also request supervised visits. She doesn't seem like she's very involved in the kids' lives. And if she's, off smoking weed a lot and around the children stoned out of her mind, that's not good for the kids. So maybe get some supervised visits for her, and then you don't have to worry about it.
Yeah. Yeah. So with the, what is that, the wiretapping?
Mm-hmm.
So they are married, right?
Mhm.
So I guess I have to look into that penal code, because they're married. So is there a presumption that, hey, look, your account's in my account? No. Okay.
No, now if he had the password, it's fine, right? But if he somehow hacked it or acquired the password without her consent, there would be problems.
Yeah, that's tough.
So for anybody listening, don't do that, right? If you have consent, get the evidence while you have consent. Don't wait till you need it and then try to hack it. So I guess to summarize that, the answer to your question is file a petition, get a TR with extraordinary relief, which we discussed about 20 minutes ago, I believe, on this same feed. And then go fight for custody, explain to the judge what's going on, and the judge will render an order that makes sure that your children are protected.
Get that disproportionate share too.
Possibly disproportionate. They're staying at an extended stay. Yeah. So anything else?
I think that's it.
All right. So we'll share my screen here. So like we said in the beginning, in the middle, and now at the end, don't take any of this as legal advice. If you have issues surrounding family law, hire an experienced family law attorney in the jurisdiction where your case is going to be held. Take the advice from them. Hopefully we provided you with some talking points, some food for thought, some great geography knowledge that you can use later. So, and don't forget to follow us on all the social media platforms, right, James?
That's it. Facebook, Snapchat, LinkedIn.
All right. Till then, you guys have a good weekend. We'll see y'all next Friday.
Adios. That means goodbye.